Aluko has dedicated her career to advocating for fairness, equity, and the rights of those who often go unheard. As public defender, she leads a team of committed people to provide high quality legal defense to individuals who cannot afford private counsel, ensuring that justice is not a privilege but a right. We're grateful to have her share her insights with us today as we continue our mission to increase voter access, civic engagement, and collective action in Shelby County. So grab your lunch, get comfortable, and let's dive into a powerful conversation. Please join me in welcoming Ms. Phyllis Aluko, and you can join me with like a virtual applause or a heart.
We do have Miss Vicky Terry here, who is going to do our partner welcome today. And after that, Phyllis and I will begin our interview. Vicky?
Okay. Good afternoon, everyone. And I just want to say that I want to welcome each and every one of you to the Shelby County Voter Alliance Lunch and Learn with my friend, our special guest, Ms. Phyllis Aluko. And she was already introduced as the first Black female Black woman to be the Shelby County Public Defender. And I am so excited about this because she has been helping around here at the NAACP for at least 8 years, because that's how long I've been here. And she was doing it even before I came. As he said, I'm Vicky Terry. I'm the executive director of the NAACP. And the Memphis branch is a founding partner. We're a proud founding partner of the Shelby County Voter Alliance. And as she said, the Shelby County Voter Alliance was founded in 2019. And our mission is to build power by working with Shelby County organizations to dramatically increase, I'm going to say that again, to dramatically increase voter access, voter engagement, and voter turnout by using data-driven strategies in civic education. Our Lunch and Learn series helped to fulfill the civic education part of our mission. These are educational sessions, not town hall meetings, but they're educational sessions. The NAACP, we are happy to continue working with the Shelby County Voter Alliance, and our mission together is to achieve equity, political rights, and social inclusion by advancing policies and practices that expand human and civil rights, eliminate discrimination, and accelerate the well-being, education, and economic security of Black people and all persons of color. As I said, we're going to enjoy today, and let's get started. I hope you enjoy today's Lunch and Learn and gain a better understanding of the Public Defender's Office. Now I'm going to turn it over to Ian. Phyllis, thank you so much for joining us, and thank you for all your help. Ian Randolph, thank you.
Put me and Phyllis on the screen. Check all the people. All right, so we are back. Thank you all for coming out. I was there when Miss Aluko got appointed to this position down at the county hall. We were all so proud of her when that ceremony took place. So we're going to cut to the chase and go ahead and get started. Ms. Aluko, can you give us a brief history of the Public Defender's Office?
Well, let me start. Well, first of all, let me start by thanking you, thanking the Shelby County Voter Alliance, thanking the Memphis NAACP for the invitation to speak about my office. You know, we are not an office that's in the news a lot. We tend to do our work quietly, and we think that's how we can best represent our clients who are facing some some really traumatic circumstances usually. So when we're doing our work, you oftentimes don't hear about what we're doing. So we rarely get the opportunity to really speak publicly about the work that we do. So I appreciate your interest in the law office of the Shelby County Public Defender. To tell you a little bit about the history of the office, I really need to expand it to nationwide. Let's look at the history of public defense in America. And the reason why I want to do that is because our office was actually one of the first in the nation to open up, one of the first public defender's offices in the nation. But most of the time when people think about public defense, they think about a man by the name of Clarence Gideon. People have heard his name. A lot of people, whether you're a lawyer or not, have probably heard of the case of Gideon v. Wainwright. It's a famous United States Supreme Court case. And Clarence Gideon was the Gideon in Gideon v. Wainwright. And he was charged and forced to go to trial without an attorney in Florida on a charge of burglary, charged with burglarizing a pool house, I believe. And they wouldn't give him an attorney. He was too poor to afford an attorney. And so he went to trial and he lost. And he then handwrote an appeal from his cell ultimately to the U.S. Supreme Court, asking them to look at the case and look at the fact that he was not given access to counsel, although his liberty was at stake. And the reason why I'm talking about Clarence Gideon is not only because he's the Gideon in Gideon v. Wainwright, but also because a local attorney, a person from Memphis by the name of Abe Fortas, was actually appointed by the U.S. Supreme Court to handle the appeal in the U.S. Supreme Court. And the issue was, are people actually entitled to appointed counsel if they cannot afford to hire counsel and the government has charged them with a criminal offense? If their liberty is at stake, are they entitled to appointed counsel? And the U.S. Supreme Court, after Abe Fortas's, the Memphians, argument, decided that yes, people are entitled to appointed counsel. Now that was done back in 1963, and people generally will credit Clarence Gideon with the start of the public defender movement in the United States. However, the public defender movement really goes far before 1963. Our office started in 1917, but even before our office started, there was actually a woman, and that was of particular interest to me, a woman by the name of Clara Shortridge Foltz. She lived in multiple states, mostly out west, but she ended up in California. And this woman was licensed to practice law in 1878, but only after having to get the law changed in California that restricted the practice of law to white males. So she got that law changed, and then she was able to become the first woman to practice law in the state of California. And when she became an attorney, she found that the cases that she was getting were a lot of appointed cases that other attorneys would turn down because the clients could not afford counsel. And so she would be asked to represent them, and she would essentially, as private counsel, be representing them for free. So she developed this concept. Her view of public defense is an official who would be the equal to the district attorney, but handle the opposite side of the case. So from her view, if the state needed counsel in order to prosecute the case, then there should also be counsel that is equally well funded. There should be an Office of Public Defense that would represent those who were too poor to hire private counsel in California. And then she expanded that idea beyond California. She developed what was called the Folks Defender Bill. She ran that bill in New York, in other states around the country, and she was not successful initially. But finally, in 1914, she was successful in California with her public defender bill. And the Los Angeles office became the first public defender's office in the nation. And think about it, just 3 years later, this is how progressive the citizens of Shelby County were on this issue. Just 3 years after the first public defender's office in the nation opened, the Shelby County Public Defender's Office opened as a result of a state private act, the Private Act of 1917. The legislature gave the local officials here the authority to establish a public defender's office. And so our first public defender's office was established in 1917 here in Shelby County. And 102, fast forward 102 years later, I was appointed to be the chief public defender for the office. So that's a little bit about the history of public defense in America, and as well as the history of public defense in Shelby County.
What is the role and the scope of the public defender's office?
Right. Well, in order to really answer that question, I would like to remind people about the role of the criminal justice system in our county, in America. I like to think that there are three broad that people should always remember when we're talking about the justice system, particularly the criminal justice system. One is due process. And when we talk about due process, we're talking about the 14th Amendment. And when you say 14th Amendment, remember, 14th Amendment is where you get the privileges and immunities clause, privileges and immunities of citizenship. That's where you get the idea of equal protection of the law, not just for citizens, but for all residents. That's where you get the idea of due process. That's where you get the idea of citizenship by birth. We're citizens because we were born. So when you talk about the 14th Amendment, that is critical. That's probably the most often cited amendment in motions and briefs that you will see in the criminal legal system. And the reason why I mention it, because the 14th Amendment has a strong Memphis connection. It was not always guaranteed that we would have a 14th Amendment. There were people in high places, including the President of the United States at the time, that Congress passed that amendment and sent it to the states, who were opposed to those rights being enshrined in the Constitution. He felt that it's Andrew Johnson, ironically a Tennessean, who felt that we could trust the southern states to handle these matters on their own, and there was no need to put these kinds of protections like citizenship by birth, due process, equal protection of the law, the privileges and immunities of citizenship. There's no need to put that in the Constitution from his perspective and from the perspective of a lot of congressmen at the time. And so there was this debate that was going on in Congress as to whether or not these rights that were part of the Civil Rights Act that had been passed in 1866, whether or not they really needed to be enshrined in the Constitution. And then something happened in Memphis, particularly in South Memphis in 1866. The 1866 Memphis Massacre occurred. And that during that incident, you had law enforcement, people of authority who essentially went through the community of South Memphis and other parts of downtown Memphis, and essentially destroyed every Black church, every Black school. Those were particularly targeted. People who had just been mustered out of service from the war, Black soldiers who were part of the 3rd Heavy Artillery unit that had been stationed in the area and had been mustered out of service were particularly targeted. People, Black people, children, women, men were killed in the streets. So it was definitely a massacre, and news of it really went viral at that time. It was in newspapers all across the country, and Congress sent a select committee to come to Memphis to investigate what happened. And the committee determined that what was called a riot in the Southern newspapers was really a massacre. And after the 1866 Memphis Massacre, Congress finally got enough votes together to pass the 14th Amendment. What happened here in Memphis convinced the congressmen that, yes, these rights really do need to be enshrined in the Constitution. And so they passed it. Now, that wasn't enough because enough states had to ratify it, but that caused Congress to actually pass the 14th Amendment out and send it to the states. And 2 years later, enough states had ratified the 14th Amendment in order to make it a constitutional amendment. And so a lot of people don't like to remember Memphis's involvement in that, but the 1866 Memphis Massacre is probably why we have the 14th Amendment today. And as I said before, the 14th Amendment is why we have citizenship by birth, why we have due process, equal protection of the law, and the privileges and immunities of citizenship, all enshrined in the Constitution. So when you think of the criminal legal system, you need to think about the 14th Amendment and those rights that it protects. You need to think about the presumption of innocence. That's the second broad category that you need to think about. Who should have the burden of proof? Well, our Constitution says that that the state, the entity that is making the accusation, that's bringing the charge against the accused individual, is the one that should have the presumption of innocence. So think in terms of that being the second broad category that is really enshrined in our criminal justice system. And the third broad category that I want you to think about is the right to counsel. And that is where we come in at the Public Defender's Office. We represent people who have been declared to be indigent, which essentially is too poor to hire private counsel to represent them on the charges. And so there are people who have been accused of a criminal act, but cannot afford to hire private counsel. And that is the role of our office. Can I say also just generally, we like to refer to ourselves as the community's watchdog of the criminal legal system. We are there to make certain that due process is afforded, make certain that people get effective, client-centered, zealous representation for every client and for every case.
All right, how does the Public Defender's Office work with the rest of the criminal justice system in Shelby County, including youth and juvenile court?
Right. Well, I think I kind of alluded to our role in the prior question, but I will say that we service all courts that have criminal legal jurisdiction in Shelby County. And so our largest unit is the Adult Trial Division. We have three main divisions of our office. The Adult Trial Division is the largest division, and it services the General Sessions courts that have that handle criminal cases. It also services what we call the upstairs courts or the circuit level courts, where you can get a jury trial that on all kinds of cases. We have a separate youth trial division that is actually right next door to juvenile court. And we handle matters in which our children have been charged with committing delinquent offenses. And so we represent the children on those cases. We also have an appellate division. And what a lot of people don't know about our role in the Shelby County justice system, they kind of tend to think that we're only here at 201 Poplar or at juvenile court, but there's some municipal districts that have criminal jurisdiction over cases at the general sessions level in Germantown, Collierville, Bartlett, and it used to be Millington before they gave up their criminal law jurisdiction. And so your public defender's office are in those courts too, those municipal courts as well. Now, they don't always pay for our services, but we service the clients who are accused in those municipal courts as well. And our role, just to repeat how we work with the other agencies, you know, the criminal legal system is a huge agency. It's my hope that sometime in the future it can shrink. You know, we like to think that we're trying to work ourselves out of a job, because we would like to see a smaller criminal legal system that actually focus on rehabilitation instead of so heavily solely on punitive. We think that ultimately that's going to be best for the community, is if we return people to the community better than what they were when they left the community. But right now it's a huge, costly system that involves not only your local prosecutor's office, but Memphis Police Department, Shelby County Sheriff's Department. You've got correctional offices, you've got pretrial services, which is a division it was part of the Division of Community Services. And we all have a role to play. And the public defender's office specific role is, as I said before, to make certain that even for the disfavored in the community, that the Constitution means what it says, that due process rights are afforded for every client and for every case. And I can promise you that you don't want to see or experience a system where there's no one acting as public defender in that system. Dr. Martin Luther King said the arc of the moral universe is long, but it bends towards justice. But it doesn't bend that way on its own. There has to be somebody whose role is to make certain that the rules are applied properly and fairly for every client, for every case. And that's our mission.
All right. What impact do cash bail policies have on your clients? And what is your office's stance on bail reform in Shelby County?
Well, I can tell you that cash bail, if you think about it, the idea of it, if you can afford a high bail, you can get out on the same charges that someone who is too poor to buy their release has to remain in custody. And what I often wonder is, does the community really believe that wealth lessens culpability? If someone is charged with a violent offense, but they are so wealthy that they can afford the bail, does that make them any less dangerous? And vice versa, is the fact that you're too poor to afford bail make you more dangerous? Well, that's why I emphasized in a prior question the presumption of innocence, because we must remember that, you know, our clients, when we are appointed, they're presumed innocent, and that is a bedrock, you know, foundational principle of our criminal legal system. We don't presume guilt. We presume innocence in the person who's making the accusation or the entity, the state of Tennessee that is accusing the client is charged with the burden of proof of proving the accusation. So when you tell people that you can be too poor uh, to be released, and then we hold people in custody in a facility in which multiple people have died recently, I wonder what is this saying about our community, about our criminal legal system? How is this really making us safer when the wealthy can get out, but the poor stay in, lose their jobs? You know, we had our office had a case recently, and I won't say names because clients are entitled to confidentiality, but we won a case recently on an offense that was a violent offense. By the time we were able to get it to trial, the client had been in custody for about 17 months because he was too poor to afford the bail. And the jury came back, rightfully so, with a not guilty. So now that client is now released, but the job is gone. You know, what's happened to housing, what's happened to community contacts, family relationships in those 17 months that he was held on unaffordable bail solely because he was too poor. And so there are issues of fairness. And I'm not going to say what the office's position is, but I will say what my position is that their bail is there to assure that you come to court, and also you know, the magistrates and judges should look into the safety of the community, but you should not use bail as a punitive measure to punish someone before a jury or a judge has had a chance to determine whether they're guilty or not. When you determine whether or not a person deserves to be out in the community based upon how much money they have, that just seems to me to be unfair. And can I just segue? I think you mentioned something about bail reform. We haven't had it's been mislabeled in our community. What a lot of the community has been hearing as bail reform is not bail reform. Bail reform would be if our community decided that we wanted to get rid of cash bail completely. And it's like everybody's either detained or you know, everybody isn't detained unless there are, you know, certain circumstances. That would be bail reform. What we did in our community was make our bail protocols comply with existing constitutional law. People called it bail reform, but it was just constitutional compliance. When I started practicing years ago, you might not get a bail hearing. You may not even get appointed an attorney for some time after you're arrested. And then you would not get a bail hearing for some time after that. We were talking weeks that go by, sometimes longer, before a judge would determine whether or not, you know, the bail that was set by the magistrate was unaffordable and wrongfully unaffordable. And that was just contradictory. to what the law said. And so what different agencies in the criminal legal system did was get together and figured out, how can we get people to bail hearings sooner? How can we make certain that no one is going weeks without having a judge or a magistrate review their bail? And when we say review, we don't mean the kind of review that occurs when bail is initially set. Because, when bail is initially set, the client's not there, there's no defense counsel there. The magistrate is reading the affidavit that's been presented by law enforcement and is looking at an arrest history. And no other information from the defense or anything is going before the magistrate. That's not a constitutionally compliant bail hearing. That's not a bail hearing where the client has the opportunity to participate. And so what we said, let's have a bail hearing. Let's figure out how the system can have these bail hearings within 72 hours as is required instead of within weeks. And that's what was termed bail reform. It was not bail reform, it was constitutional compliance. And I'm not saying we don't need bail reform, but I'm saying what our community did was not bail reform. It was trying to figure out ways that we can get people to their hearings within 72 hours, even on holidays. And so we have our office and our people volunteer to do this because we don't get paid any kind of overtime for working on holidays, but we get people, attorneys, who sign up for every holiday that we need to have a special docket, because if we don't, then the people arrested shortly before the holiday will end up having to go maybe, close to a week before they would get a judge to look at their case and determine whether or not the bail was appropriately set or not. And so that's how strongly we believe in making certain that constitutionally compliant bail hearings are heard, and that they're heard timely so that people don't lose everything before a judge even takes a look at it and sees whether or not a mistake was made.
All right. The Public Defender's Office has had a long-standing staffing shortage. What is the state of the staffing currently? Have there been improvements? And if there haven't been any improvements, what needs to happen to resolve the shortages?
Well, it is true. It's not just our office. Public defense in general has been underfunded. And as a result, when you underfund, where you put your money determines where your priorities are. And as a result of underfunding, there have historically been staffing shortages nationwide. So it's not just us, but to speak about our office, yes, we have struggled with staffing struggles as caseload increases, as more and more criminal offenses. As more and more things are criminalized, more people are going to be arrested. As more and more people, as judges are encouraged to impose unaffordable bail on more and more people, our services are needed more and more. So we have struggled. That said, we remain and have always been the largest public defender's office in the state of Tennessee, frankly, in this entire region. Currently, we have 81 full-time attorneys with our office. That makes us not only the largest public defender's office in Tennessee, but the largest criminal defense firm in Tennessee, public or private. So that's where we are. We've made progress and I want to give, I want to give credit where credit is due. We have felt supported by our county government that recently appropriate funds so that we could achieve get closer. We're not there yet, but get closer to pay parity with the other public defenders' offices across the state. So although we are the first, we're the oldest, we're the largest, we were also the most underfunded. And as the percentage of state funding did not keep up for our office to the same degree that other public defender offices across the state were funded. And as a result of that, we fell behind, and that's going to have an impact on staff retention. It's going to have an impact on recruitment. So we've worked really, really hard. We're at, as I said before, the level of 81 full-time attorneys. We have some temporary attorneys in addition to that. But the full-time attorneys are the lifeblood of our office. And we have two additional full-time attorneys that are in the appointment process. And the program I'm about to mention is something I'm really proud of. We developed during my tenure the Public Defender Fellowship, because we realized that while we were dealing with issues that were out of our control of pay parity, pay disparity, let me say that, and things like that, while we couldn't control that, we could look at what we could do to try to begin to develop the next generation of public defenders. And we developed our fellowship program, which encourages law students to come and join us. And we identify talented law students who have an interest in indigent criminal defense while they're still in law school. And we're able to give them job offers as part of the fellowship program, the same way maybe a private firm might extend a job offer to selected students in law school while they're still in law school. And so we have 7 law school graduates who are in the process of studying for the July bar. And hopefully after those results come out, they will be joining us as full-time public defenders. And so if you count the 81 that we have, the 2 that are in the process of being hired, and the 7 that are part of our fellowship program, we have about 90 slots that are occupied right now, which means that we've cut our vacancy rate down to about 5 full-time public defenders, if you count those that are in the process of being hired.
All right. We have about 15 minutes left. I want to try to get through at least 3 more questions. Please explain the work of the reentry unit that you started after 2019, and what are some of the major successes that you've seen and work that still needs to be done to support those who were formerly incarcerated or detained?
Let me say that our reentry unit kind of grew out of some work that I did with the Memphis NAACP years ago. And it stemmed from when the legislature made some changes to the restoration of citizenship law. And the community really did not know about the changes. And so through the NAACP, we held it wasn't really a forum. It was more of a one-stop event where we invited people all of the various agencies that to come. I believe it was on a Saturday, and it was done at Mississippi Boulevard Christian Church to be there so that citizens could come by and see if they could get their rights restored. And we had, representatives from probation agencies, I think the Department of Corrections. So we had various agencies there to provide information and hopefully help for members of the community to get their rights restored. And I realized when looking at the long lines of people who showed up for that. I mean, now we're used to seeing it. Expungement fairs and things like that are pretty much held on a regular basis now. But back then, I'm talking, probably 20 years ago. But back then, we did not have those kinds of events every day. And I saw the need in the community. And when people are struggling with those kinds of issues, they really impact how well they can reintegrate into society. They've served their time. They've been punished. And the question is, should the collateral consequences of a criminal conviction be permanent? Some people, that's a question for the community to answer. The law says they don't have to be permanent, but the way things are organized, if you're struggling with the collateral consequences of a criminal conviction, it's probably affecting what kind of job you can get. It may be affecting what kind of housing you can get, which affects so much more. So are you going to take your scarce resources to hire counsel to try to get some of those collateral consequences lifted? Or do you even have the resources to do it? So I felt that our office was there when the rights got taken away. When people are now eligible to have the rights restored, we ought to provide some sort of help, some sort of guidance to the community in getting it restored. And that was something that just didn't exist. There were all kinds of rehabilitative and reentry programs that focused on very important things like housing and job skills. And that's not what our reentry program is about. But they didn't really focus on people getting their legal rights back. And so we thought that was a niche in which we could provide some information for people who are eligible. And a lot of what the unit does is try to get people to the point where they are eligible. A lot of people don't even know what it takes, don't even know if they're eligible. The reentry fairs and things that you see around town, they're oftentimes, they do excellent work, but they're oftentimes restricted to helping people with what I call low-hanging fruit. Well, most people's situation is a little bit more complicated than what can be handled at a reentry fair. And our office provides a resource where people who with complicated matters, but who are still eligible by law to get their rights back, can come and we can go through the complicated issues, and we can develop a plan of action for them. And for those who are eligible and for whom we can help, we help. And for those who are not eligible, we still feel like we've provided the service because now they understand what it takes. They understand what the rules are, and they understand why they're not eligible. But it's a unit that I really wanted to start, and it's staffed by 2 part-time attorneys with our office. So we don't have enough staff, but they've been able to help a lot of people. And a lot of it, frankly, comes down to court costs. People don't realize how much debt. People get into generational debt by having a case down here. You don't know the kinds of fees. When I was a new attorney, I remember representing someone and I looked at, we were about the same age. And I looked at his court cost bill and I realized that it was as much as I owed in student loan fees, except for I graduated with a diploma that allowed me to get a job to pay back my student loans. And here he was with the same amount of debt, but he was he was leaving with a record, or had established a record that would prevent him from ever paying. And he would never be able to regain rights like voting rights because they're all tied to court costs. He would never be able to regain driver's license privileges, which were tied to court costs. There's so much that's tied to court costs. The rights that my forefathers and foremothers, fought and died for, every day at 201 Poplar, those rights are being taken away. And if there's not some agency that steps in to help guide people through the labyrinth of rules and regulations and try to ease some of the court cost burden on the people who have already served their time, then these will be permanent revocations of the right to vote, permanent revocations of the privilege of driving. It just, even the expungement law, if there's no one to help navigate people through it, there are a lot of people who might be eligible who don't even know that they're eligible. And that's what our reentry unit for our office is all about, to help our clients when they get to the point that they're eligible for some of these relief, some sort of relief from collateral consequences, that we can help our clients access the relief that they're entitled to.
All right. Are there any policies or bills that you think residents should be paying attention to that would affect public defense or criminal justice more broadly?
I can talk in terms of policy, not politics. So I can tell that's kind of why I emphasized at the beginning, during one of the beginning questions, remember the 3 bedrock principles of our criminal justice system: due process, presumption of innocence, and right to counsel. And anytime you see something that is challenging those principles, the community needs to ask questions and needs to be worried. A lot of times fear, Attorney Brian Stevenson, who's a famous criminal defense attorney, says that the politics of fear and anger, that's how he terms it. And the politics of fear and anger are oftentimes used to undermine systems of justice. And so if you see anything that's being proposed that you're asked to vote on, if fundamentally it's going to be a challenge to due process, to presumption of innocence, or to the right to counsel, you need to be concerned about whether or not it's necessary to weaken those principles in order to attain the ultimate goal that is being proposed. And I think that's the best that I can say it without wading into political waters.
Okay, and as we discussed, we are nonpartisan. We do not support parties. We do not support individual politicians, but we will stand behind an issue. Having said that, are there any ways that the Voter Alliance and other community members can support the work of the Office of the Public Defender?
Absolutely. We need your support. I'm encouraging our team members to get out in the community more. So we need to be invited into spaces where we can also learn more about the needs of the community. Because we're laser focused on the needs of every client in every case. But there are, we do need to be connected more to the community, and so that hopefully we can better service the community as it deals with some of the broader issues. I can say that there's one issue that has been a long-standing issue for me in the system, is the time that it takes to between a judicial decision at a preliminary hearing at the general sessions level and the presentation of a case for indictment. I think it takes too long. And the problem with taking months for a person to be indicted is that as the community moves more towards trying to incarcerate more and more people before there's a finding of guilt, as the community moves more and more towards wanting unaffordable bail for the poor, then your jails are going to be clogged up with more and more people who actually could be safely monitored out in the community while they're waiting to have a jury determine guilt or innocence, or a judge, if they have a bench trial, determine guilt or innocence. And so you are there's creating a really pressure-filled situation with more and more people being detained, and then it takes months. They're sitting there months for indictment, months for presentation of the case to the grand jury to determine whether the grand jury will indict. And what I think a lot of people don't realize is that the case can't really get started until a grand jury makes the decision whether to indict the case. If someone wants a jury trial, you can only get that in criminal court. And the cases go through, most of the cases go through criminal court through the grand jury process. And if a case is not even presented to the grand jury for 3 months, 4 months, the attorney doesn't have discovery on the case. You're not entitled to discovery until the case is indicted and the person is arraigned in upstairs court or circuit level court, criminal court. And so you've got what we call months of dead time where nothing's going on with the case. And you've got a client who's in custody on unaffordable bail. As a practical matter, that drives up the plea bargain rate. If you are stuck in custody on unaffordable bail for months and your attorney cannot tell you when your case will be presented for indictment, because defense doesn't control that. Defense is not even allowed in the room when the case is being presented for indictment. That's all the prosecution and the grand jury. So we can't tell you when your case will be presented for indictment. We can't give you any kind of idea about when it will be presented. It can take months. And if you are stuck in custody, waiting for that unknown date when you'll finally get to court to be able to start to present your defense, by the time you do get to court some months later, and someone tells you, well, now we can put you on the jury trial list to have a trial months down the road, maybe even next year, depending upon how backed up the court docket, the trial docket is. Or you can take this plea bargain and you can get out of this horrible, inhumane place that you've been in for all of these months. What do you think most of our clients do? A lot of our clients take the definite date that this will be over, as opposed to fighting it at an indefinite jury trial. And so I think that if we could recapture that months and months that people are just sitting in our pretrial detention facilities, just waiting to have their case presented for indictment, I think that the system would be better off. I think due process would be better off. I think there would be fewer innocent people pleading guilty to get out of horrible circumstances, because it just takes too long. You know, people always want to hurry up. Defense counsel wants, you know, the case has actually been indicted and they're in criminal court. People want defense counsel to be ready immediately. But that's when we finally get the evidence. That's finally when we get the discovery. We're not entitled to it at the general sessions level. And that's when we can do some additional investigation and start preparing a zealous client-centered defense. But no one says anything about the delay that is completely out of our control, that is generally months long. And every state doesn't do that. I did some research that really kind of did a survey some years back of asking defenders in other states what is the situation in their jurisdiction. And I found out that in some states, they put pressure on the system to honor due process, to honor the presumption of innocence. They say, yes, you can detain this person on unaffordable bail, but you've got to prioritize this person's case. If you're holding them on unaffordable bail, you got to prioritize their case. You've got to present their case to the grand jury within a certain amount of time. And if you don't present it, then we're going to let the person out of jail. We're not going to dismiss the charges, but you have a certain amount of time to do this. And we don't have that here. Speedy trial rights mean nothing if people think 90 days, 6 months, 9 months is speeding. So I think that the community needs to look at that, that delay, that pre-indictment delay. And we need to fix that, because I think a lot of people are going to plea bargains in order to get out of a situation that they're too poor to buy their way out of, like wealthier accused people are.
All right. Well, thank you. To everyone who has hung in there with us for the extra 5 minutes that we have run over. I do appreciate you staying. Next month on the 21st, we will have another Lunch and Learn with our Registrar of Deeds. So look for that information to come out within the next couple of weeks. With the Voter Alliance, if you would like to volunteer to help us in any way, I have put the link to volunteer with us in the chat. As you know, we are nonpartisan. We don't support parties. We don't support candidates, but we will support an issue. And just to let you know, we touch everything that has something to do with voting. So until next time, I hope you all have a wonderful rest of the day, and I look forward to seeing you at our next Lunch and Learn. Thank you. Bye-bye.
Thank you.